Hi everyone. We are about 15 minutes late, but still great welcome to this webinar with Mr. Raja Sujith, who is a partner at Majmudar and Partners in the Bangalore office, and has been handling labor and employment law related matters among many other things. Today we will be talking about labor and employment law, and I'm Ramanuj Mukherjee from ipleaders, and this is my I'm doing a webinar with you guys after a long break, so it feels good to be back. Yeah, so welcome. Now I have already introduced Mr. Raja Sujit, and I'll also like to add that he has earlier worked with Fox and Mandal, India's one of India's biggest law firms. And why don't we hear from him? How his career has shaped up till this point, and what are his areas of expertise from his own mouth.
Hi all, thanks Ramanuj, and so just to give a brief introduction of my career, and my name is Raja Sujith. He has already mentioned. I started my career as a litigation lawyer in '95, and about 6 years I was a litigation lawyer, and moved to Bangalore. As he mentioned, I was with Fox Mandel for about 6 years. And 2006, I started the Majmudar and Partners Bangalore office. Uh, and so I deal mainly with, surely as he mentioned, a lot of employment law work, corporate M&A, and bit of real estate. That is the kind of work I do. I think enough of introduction, and let me get to the topic we are going to discuss today. So basically, we are going to deal with employment law in India in a generic sense, but with a specific kind of angle to it is from a new industry perspective. So sometimes I may not be really dealing with some of the kind of factory kind of issues, but it is a new industry like IT and ITS and new electronic industries and all those industries.
Yes, I think even most of our viewers today are interested in the new economies, and in fact, many of them are startup entrepreneurs themselves.
Right,
Many of
right,
them are law students and
absolutely.
lawyers as well,
Yeah,
practicing lawyers. But I think everyone is interested in understanding how this labor and employment law related issues are working for the new industries. And I
right.
think, I mean, that's where your contribution today will be very, very valuable to them.
Yeah. So and also, if you look at the way, I hope you people have already seen the, kind of synopsis. So what we are going to do is just to give a, kind of brief introduction on what is the Indian employment law. I'm sure you are all well aware, you have already read it, and you have studied on this. Um, and also, so if you look at, I just wanted to see a company, right? So, for example, an IT company, what they are, so from hiring to firing. I mean, that's firing is not a word we normally use, but hiring to firing. I mean, that is a kind of lifespan of an, kind of employee. And so we just wanted to take you through that, and in a very generic sense. I mean, we are not going to get into 1 hour is not long time to discuss on the entire thing in depth, but we'll just go through what all things an employer will look at. Again, new industry perspective. Just to give an introduction, so if you look at, so in India, so the labor, the word labor, and kind of concept of labor is used very early. You look at it in 300 BC, the Chanakya, the Kautilya, who has mentioned in Arthashastra about labor, and it is, we cannot imagine now. Actually, they have prescribed a comprehensive labor regulations during that period. It's a Mauryan era. He was a chief
That's
minister
very
of
interesting.
Chandragupta Maurya. So I think that time onwards, historically we have seen employment law or kind of employee related issues discussed. And even post-modern era, you will see some of the labor-related issues discussed by Manu, who has written, Manu Smriti, and a controversial one. But I mean, they also covered the labor law issues. But if you look at if you trace the history, the modern labor law history, we'll end up in the British laws. So some of them are actually, copied and, derived from British laws. They have introduced these laws to protect the British employers. I mean, kind of all those, so kind of employee issues. Main reason for these laws were to protect the British employers in India.
Mm-hmm.
So one of the earliest, act was like, 1929, there was a Trade Disputes Act. If you look at, almost like our Industrial Disputes Act of 1947, it restrained strike and lockout, to give an example. But there was no machinery to, kind of take care of the dispute and all. And that act was repealed, and then we have the current Industrial Disputes Act, that is the 1947 post independence.
And I believe it was one of the first laws that our independent legislature actually drafted and passed. Yeah.
Right. And so moving on to our constitution also, covers the labor. The subject of labor isn't under concurrent list. So that's why we see, different laws. Both central and state government are competent to enact laws subject to certain matters are actually reserved for the central government. So this is something which we see. We may not see in some of the other countries when we meet lawyers from other countries. Normally they wonder, I mean, how do you manage? I mean, kind of the laws, the kind of, to give an example, like holidays in one state, in Karnataka will be 20. But if you go to Delhi, it will be 18. So this is something which we see. Lot of laws are, kind of state specific. So that's where Constitution has given that as in the concurrent list. So
I will just ask one question here. Okay,
please go ahead.
So we have seen that this is a general question that many people have, because now we have businesses which are not located just in one state. It may be a small business, but they are operating in several states. Right. It can be even an NGO which is having not having a lot of resources, but operating in 3 or different 4 cities which are in different states. Now, do you think that they really need to focus on each these laws, like, or while making strategy when they are not setting up factories or manufacturing, but could you maybe today cover this aspect during your talking, what they need to think about it? How can they strategically think about it? So if I am a new age business, I'm a startup, so I am basically, let's say, a company which is take a simple example. I am I have 10 people in 5 different states, where these 10 people go to different restaurants and make a list of restaurants in India and putting those up online, right? Now, something like that. I'm just taking an example. In those circumstances, although they are operating in 5 different states, do they need to really create some strategy for each different state, or can they follow a simplified general mechanism?
Yeah, so if you look at that's a big challenge in India. I mean, so you are giving an example of a startup, right? So, 1 or 2 people, kind of, then it's slightly different. So how you are going to do things. But if you want to start your own, let me just, as you mentioned, let's for the time being get the kind of factory environment out. So the new age industries, like you're going to start a software industry, then you have offices in several places, right? So initially you will be able to manage. I mean, if he is in one place, basically there are certain basic registrations are required for an establishment. It is not a certain registrations like provident fund, right? You can manage it from your one of the offices, okay? But if it is, for the shops and establishment, it has
Okay.
to be from each state. So, when you go for a registration, I mean, I'm just getting into the practicality of it. Then they will ask for a, kind of, you have to have an office space sometimes. Otherwise, you will be managing, the example you have given is, 8 people, different places. You will manage from one place and, you tell that this is the establishment and other people are around, So, for example, marketing guys will go around, you have to, for the time being, you have to look at that way. But if you're really starting an establishment, you have 5-10 people in a establishment, you should look at the office space. I mean, sometimes some of the officers will allow you to be in your house and all those things, but normally they will look at it as a commercial establishment. So it is very important for you to look at, to give an example of your, so how many holidays you will give. You have
Okay.
5 employees in Karnataka. So Delhi, you give only 5 holidays. Okay. Here it is 10. That is the minimum requirement. So you have to have some employment policies which will be little better than the best of the best among the all laws where you have offices. That's the way you have to look at. Then you are safe. I mean, it is all minimum. If you look at most of the employees, these are all welfare legislations and these
Welfare.
are all minimum requirement. So if you give it anything more than that, it's perfectly fine. So I think that is the way you have to strategize. And
Okay,
we have,
you have said something here that I want to ask another question. Like this was
right,
very interesting, that we can formulate a general policy that
right,
this is the minimum, which is like more than the minimum prescribed by any of the laws. So we
right,
can reach at a number like that, and we can reach at a situation like that. Apart from the registrations, of course, which have to be at individual places.
right,
Okay, if that is the state requirement. Otherwise, we can create an employment policy which is similar for the all of the country, no matter how many offices I have,
right,
and then I can have a good policy which is better than the minimum welfare suggested, and I'm
right,
safe. So
right,
that is a very interesting thing. But you also said something that you should not be operating out of residential places. You should have an office space. So we
right,
have seen in a lot of places, and especially like in new age economy, we are seeing that uh, the idea, even Google, your Apple, or any of the eBay, they started out of their garages, right? That's the
right,
idea that you start a startup from garage, and in fact, the Apple II, which was the who changed the history of computers, was launched from the same garage, right? So
mm,
you also said that you have a little bit of background in real estate, so I'm tempted to ask this question.
right,
What
right,
is
right.
your experience in India? Do we allow
Yeah.
our Googles and garages, the Apples, to grow out of garages in India?
No, so whatever you mentioned, examples, Apple or kind of all of them,
Hmm.
all started in US,
That's
right?
true, of course. Yeah,
So
Silicon
yeah,
Valley.
so if you look at strict legals, and that is one point, so if you look at, I was trying to cover, the most of these laws are actually not going to, kind of make available all these options.
Okay.
It's in the strict sense. If you
Hmm.
look at, if you're registering under shops and establishment, they can
Hmm.
always insist that it has to be a commercial establishment.
Okay.
And you have other issues also. For example, you start something in, in your, if you look at most of these housing societies,
Hmm.
or your flats, or your villas, there will be specific kind of insistence that you should not start anything and commercial establishments in that
Correct. Correct. Correct.
residential block. And
Hmm.
once they register, so they can come and inspect your place. It cannot be in your, I mean, these are all I'm talking about a strict legal sense, right? The
Yes. Yes.
strict legal compliances. If they want to make, I mean, let me not, so make you your business little difficult, they can come
Difficult.
and inspect and tell, what is this? I mean, it is your house. I'm not going to allow this.
So
So,
I have a question here.
but
Hmm,
the
hmm,
same time, I mean, if you look at,
hmm.
the place like Bangalore, so we see a lot of startups and, kind of, and there is a way out. People, okay, it is okay. I mean, you're doing the business, right? You're not going to do the, kind of,
Manufacturing or something.
manufacturing, and you're not going to disturb. You continue. It is not under the law. That's
Hmm.
that's the, that's a one thing we have to always remember. So we are not reached in that level under the statutes to allow all these things. I mean, that is one point I wanted to cover. Yeah, go ahead.
Hmm. Hmm. So my question is this, like, there are two kind of. I want to make a small distinction, right? So we have some situations where there is a housing society, which is a residential society, and no one, the understanding of that, housing society or the cooperative is that I don't want anything commercial here, which is understandable. But there are other situations where there's an independent house, or maybe it's not a residential area as such, and people are running shops on the ground floor. That's a common thing, right? We see everywhere in India that on the ground floor there are a few shops, right? These are commercial establishments. But the moment you start an office there, in some places, and I think this law also differs from state to state in this regard. But generally, the idea is that some places you can do it, and other places,
Okay.
even if the house owner is willing to let you do it, and there is no one is being a victim here, still they will not allow you to do it. Is
You know,
that
so,
correct?
so again, so I think you mentioned on the real estate side, right? That's what
Hmm.
you're, I think, aiming at, right? So basically, there is a specific, so the usage of that, maybe a flat or a house, you can actually change that usage. Okay, at least in Karnataka, and all, what we'll do is the one big objection will be from the electricity board.
Okay.
You
Hmm.
you have two kind of tariffs, right?
Hmm.
For the residential users, this is the tariff, always the discounted tariff. And if it is a commercial user, it will be different. So that's the first and foremost thing you may have to do. You convert that into commercial. So that is one, kind of authority will come and hit on your door. So that is conversion. And under, property law also, you have the right to change the usage of the land,
Right.
usage of the, kind of property. So that
Hmm.
is something which, if you do, then it is a commercial space. And we see that, if you look at, in and around you, there will be a lot of residential colonies, and suddenly it will become a commercial space. And
Right.
you
Right.
see that it is a purely industrial area, they will make it a commercial space. Or, all those things will happen. But generally, these are all not possible for a startup and, kind of an entrepreneur, right? So he wanted to
Hmm.
start in his garage. That is what you
Yeah.
mentioned. So
Yeah.
then you have to deal with the, concerned officer, and they should also understand. And that is the way you do that. I mean, it is it's not like in the
It's
US
sort
Valley.
of it's
US
not a
Valley,
black and white situation. Yeah.
correct, correct, correct.
Okay. 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 Very
Shall I move
interesting.
on? Yeah.
Yes. Yes. Please.
Yeah, so generally, so in a kind of very so all these labor laws, if you look at all students obviously will be looking at the industrial law book, right? So it is under that bracket. Um, uh, so basically, industries are two broad categories. We have already mentioned it is a factory kind of a situation, and you have a shops and commercial establishment, as you were referring to, mainly.
Hmm.
So I just wanted to bring in another aspect of our labor, kind of population, right? If you look at in India, more than 85% of the working population is in unauthorized sector. We are talking only about, kind of, the authorized sector is only 10-15%. So where we are all sitting and, kind of having office and all those things. Many of the laws will be applicable to them. Uh, and also, different laws have come up for addressing their issues also, to give some of the examples, like building and construction workers.
Okay.
Excuse me. Nobody sit in an office and do work, right? So you are in a, construction site, and you do work. So how
Hmm.
do you, or it is not an, it will be an unauthorized sector. So then there is a 1996, there was an act. Then there is you look at the plantation workers. There is a plantation labor act. Then BD and cigar workers. So all those laws have come in place in the, 90s and 80s. That is what the recent one I just wanted to highlight, which has come up, is an Unauthorized Sector Workers Social Security Act. That is a 2008 one, and
Okay.
the 2010 one is the Domestic Workers Welfare and Social Security Act. I mean, these are some of the laws which has covered for the unauthorized sector.
Okay.
And just to mention on the point which we have already discussed, right? So most of the laws are in 40s, and before that, and the 20s laws are followed. So most of the laws are really not in a position to address the new generation industry issues. We were discussing how do we start some offices. If you look at, you have a laptop or a phone. I mean, tomorrow it will be a cell phone. I mean, decent cell phone. Then you can work with that. I mean, you don't need to go anywhere, right? So I think all these issues are not really addressed in most of the laws.
Correct. I
If you
think
look
there's
at
a whole question that people ask, about what if there's this question of like flexi time. So people are
right,
not a lot of they're telecommuting, right? So
correct, correct,
there are companies are being built where there is no office at all. Like people are
right,
entirely working from their homes, from cafes, and these are
right.
becoming $1 million companies as well.
Absolutely, absolutely.
So
So so we don't have anything, so any statute which are addressing those. I'm sure these are all things kind of under consideration. You mentioned on flexi time. Even I was thinking telecommuters and
mhm.
part-time employees, work work from home situation. So I think so we will have our own laws, but within the laws, you define certain things, and kind of interpret certain clauses, and kind of work around that. I mean, that's what
Okay.
we are doing now, because so the same issues. I mean, recently I was in one of the international bar associations. There was a we, actually I have contributed on these issues. I mean, we see most of the developed countries have already addressed these issues, and they have clear laws. I mean,
Okay.
so but we have to work around from within our available laws.
Okay.
So I think so then we will move on to the hiring part, right?
All right. Sure.
Yeah. So if you look at, so one thing I wanted to, we don't see that, and again, it is not specifically mentioned in any law that, you have to have a background verification. So we
Okay.
can also call it as a hiring due diligence. That's very common now. I mean, earlier and all, you appoint someone in a factory, so whether he has all physically he is fit or not, that's what you have to see. And he's going to do the same job again and again. But here that is not the case. There are a lot of confidentiality issues involved. So the background is a very important, you know, aspect for most of the employees. It can be a pre and post employment background verification. So you before you join, they will do, and also post employment. And if they find something wrong, I mean, it is an employer has the right to take it up.
Okay. So I have a question here. Is it
Yeah.
there are I see some potential privacy issues. So is it necessary that I take consent of the employee before I actually do a background check?
Um, Normally you take, I mean, it will be part of your offer. And sometimes before you actually get interviewed, there will be a background verification.
Okay.
But you will, the only thing is that there you will not really get into the privacy issues, right? So you will not really get into the you are some of the companies will look at certain aspects, but whether it will come into your privacy or not, you have to be careful. I mean, and also when you get into the, it may not be the mid-sized and small companies. The big companies will always get, kind of agreement on the privacy issues.
Okay.
So basically, but verification part, so most of the things are not going to really come under the privacy law bandwidth.
Okay.
uh, to look at, so what are the things they really look at, right? So resume verification, I don't think it is, you have given a resume, they naturally it will be looked at.
Okay.
And your address verification, it is not going to really affect. Educational qualification, that is a big challenge in India. I mean, most of the people have certificates from different places, and you have a big challenge. So that is
Okay. So
something which
someone is
people,
claiming that I am the topper of my batch in IIM Ahmedabad. So you have to check whether he actually is.
that is one aspect. The other aspect is that you have some university. We don't know what university.
Okay.
You get a certificate and you go. I mean, how do you check? I mean, if it is if universities are there around us, so it is
Okay.
not only in IIM or IIT or law
Mhm.
schools.
Mhm.
So you can have some certificate, right? So that is big challenge. So that is a big challenge in India. And your previous employment, I mean, you can actually go on telling that I was the topper, I was so the best performer in the earlier, whether you were there or not, you have to actually check. So that is one thing.
Mhm.
And also criminal or police record, these are all not going to be privacy laws issues.
Okay.
But some certain critical industries will also look at your background in terms of your family. That has a little bit of gray area. But these are all normal issues.
Okay.
And yeah, so if you look at, so some of the, the where it started is like some of the outsourcing contracts itself will have a specific requirement that it mandates that, so you should have proper background verification of all the employees. So then that is something which you will have to do.
Okay.
So that is one part. Then we will move on to the
I have a question here. Like this
yeah,
is something we have seen very often. What happens is that one of the joining formalities will be that you have to submit a some sort of a closure letter or like a release letter from the previous employer. Now
right.
we are under the it has been in the news that some of the IT companies in India have come together and created a database of people who have violated maybe bond requirements, as they say that this is you have to work for at least 2 years, 3 years.
Hmm.
One thing I would
I'm
like you
going to
to uh, I
I'm
would
going to
like you to
deal
throw some
that
light
yeah.
on that. Also, on the fact that when you are doing background check, uh, you know, these kind of checks may also come into play, right? So if
Yeah,
if you have anything to any
yeah,
legal angle on that.
yeah. So employee bond I'll reserve now because I'm dealing it with that later. So I'll come to that. On
Mhm.
the background verification, naturally they will ask for a letter from the previous employer, a release letter. Okay, that's a big challenge for them otherwise.
Huh.
Apart from that, I mean that's a regular requirement. Apart from that, they will also do a kind of verification through the HR in that normally you get calls from the HR, directly call the previous employer and check maybe an immediate senior, check whether it is all fine. So is it right? So he worked from here, this year to this year in your organization. That is a separate check. The release letter is right. I mean, people really ask for that. And that's a big
Okay.
challenge, when you don't give proper notice, when you just say, you don't really say normal and decent bye to the company, and you just move on. Then you have that problem in some of the companies to join. Yeah.
Hmm. Hmm.
So
Yeah, but wouldn't you say like in many circumstances, getting this release letter is not always even if you have done everything fairly and correctly, and the company may not give you release letter because it's
no,
just
no.
up to them. And
No, I don't agree. I mean, maybe the law firms may not have that culture, but most
Mhm.
of the IT industries and all they will give because it is important for them also. Because I do advise a lot of companies on the firing issues from different levels.
Okay. Mhm.
It is very important for them to keep a track, and so each employee will have a file. They
Mhm.
should have a proper end to it. Most of the clients came back and requested that this guy is missing. What am I going to do? So that's a big challenge for them. They are always fine to give kind of release letters, no doubt.
Okay.
Yeah, just a moment. Yeah. sorry. Uh, so your other issue on the employment bond, I mean, I will touch up later. Okay.
Sure.
So let's get into the employment contract. Are we on time, or we are almost? So we have some more time, right? So let me get employment contract is a contract of employment is like any other contract. You should have you know what we studied on the Contract Act. Essential features have to be there. There should be an offer and acceptance. Uh, uh, there should be a consideration. There should be competent parties to it, legal object and free consent. These are the main objects. I mean, for any contract, it should be there for that. There is no requirement that you should have a written contract, right? So it can be oral also, but preferred mode is a written contract, and tomorrow we don't know what orally we have agreed. Now we can actually record it and give, but we are away from that. There is no specific format actually recommended by any law. However, if you see some of the Shops and Establishments Act of certain states will prescribe a form of appointment letter. You should look at your, whether it is within that parameters or not. General terms are, when is your work commencing, period of employment, place of work, what is your title, hours of work, salary, compensation, allowances, then whether overtime work will be considered. But new industries, overtime is a different story. Let's not get into that. Leaves and termination. These are the main, kind of sections covered. And some of the important aspects, I'm sure you will have some questions also on that. One is on the non-compete. Whether it is valuable for an employer in India. Can we push it on the employees? Section 27 of the Indian Contract Act actually invalidates all restraint, whether general or partial, in a kind of contract. It is a negative covenant restraining from joining any other employee, not valid. That's what our courts have already found. Especially after the term of employment. If you during the term of employment you can have non-compete, you should not do that and this and all. But after the term of the employment, it is not really going to be a successful clause.
Correct.
We have a lot of cases. I'm sure most of the people know about Pepsi versus Coca-Cola. That's a Delhi High Court judgment in 1999, and it is people have gone and joined the other company. It's a competitor company. You have clauses, but court said forget about that. It is a right to profession and 27 of the Contract Act. You cannot do anything. Same kind of. You
cannot enter into a contract which says that it will impose a obligation on me not to do business or not to compete with you. So you cannot tell an employee that if you have worked with me, you're a software engineer, you worked with me, so you cannot work with another competitor company, because he's going to say, then if I don't work with your competitors, then where do I go and work? Because
right.
I'm jobless, right? Essentially.
Yeah.
But I have a question there. So it is okay with an employee which is who's just an employee. But what about, let's say I have a partner in my business, or I have a CEO I'm appointing, or I'm actually acquiring a company. Okay, like you said, you do a little bit of M&A, right? So let's say we are acquiring a company, and we are hiring a CEO and entering into the employment agreement. CEO of the company getting acquired, right?
Right.
Now, in those scenarios, do you think a non-compete may be viable?
Yes. I would say yes, but the first thing in any judge's mind will be that it's not right. But if it's somehow the business is really related to that, and you can connect to that business, it's not like any employees. I mean, CEO or your partner. It's a business decision. Then it is a different thing. So the case-to-case basis, but generally, in an employment scenario, non-compete will not work.
Okay.
But again, you made a statement in the beginning. I just wanted to look at that. You said you cannot have a clause in the agreement. I don't agree with that. You can have a clause, whether it will be you'll be able to really enforce or not. It is a different thing. But
Yeah, so we actually talk about this psychedelic contracts, right? A lot
right,
of contracts that we see are like a lot of mumbo jumbo written, but
right,
not always
right,
enforceable. And in fact, the people who have drafted the contract know very well it's not enforceable,
right,
but
right,
still it is being put into place because most people have no knowledge of that, so that
right,
they will see the contract and say, okay, it's written there, it must be the correct thing, and they will not
right,
take it any further. At especially unsophisticated users or clients will not
right.
take up those issues.
Yeah, but again, so my experience, I see that these clauses have a deterrent value.
Deterrent value.
Yeah, it is always there. I mean, you don't want to, you agreed on something and you think twice, thrice before you get into, violating that, whether it is legally right or not. I'm telling you from I know all these things. When a lawyer also will think twice because I have
Mhm.
agreed on that. Is it right or not? So there is a deterrent value. So if you see my contract also, so whatever I reviewed also will have a non-compete, and it
Okay.
it can be argued at a later point of it. It is not a closed chapter, but very difficult. Employers have to be aware about it. It is not going to work.
Mhm.
Yeah, and yeah, and I'm coming back to the employment bond issue which you mentioned,
Okay.
because again the same section of 27 of Indian Contract Act prohibits that, because it is going to you know curtail the an employee's right to terminate employment. So it prohibits. But if you have that doesn't mean that you don't have employee bonds. You have. If you violate that, whether you can tell any employee that no, you cannot go out of this office. You have to be here for 1 year. You cannot. The only option you have is remedy is a reasonable compensation. This reasonable compensation has been discussed in a lot of case laws. For example, you are an employee, and the employer has spent a considerable amount of money on your training, and training is over. You say bye, and I got a better job opportunity. At least what you spend on that training, not internal training and all. I mean, you get all the soft training and other internal training you forget. I mean, you spend and you send someone to outside and train. So you can always claim it as a reasonable compensation if you have an employee bond. So
Okay,
I think,
correct me if I'm wrong. I want to understand this very well. So now
right,
I have this option, right? That I can that I have sent someone for a say I sent someone for a training with an NIIT on some certain aspects, and that person got a training for a month, and I paid 2 lakh rupees to NIIT for this training.
right,
Now this is all documented, okay?
right, right.
But when actually at the time of the person leaving, I cannot give him the bill and say that you pay 2 lakh rupees, even if it is written in the contract. So I'll have to
No,
go to the
that
actually to the court and try to enforce this. Not it's
no,
not
no,
going to
no. Hold on,
happen.
hold on.
Hmm.
If you have an employment bond, or a specific provision under the his
Contract.
contract saying that this is the money we are going to spend on you on the specific training, and
Hmm.
if at all you are leaving before 1 year, or I mean, reasonable period of time, everywhere you have to look at a reasonable period of time, then you can tell that, so then you can enforce that.
So you're
So
saying 1 year
you
is
cannot bring
reasonable
it
for
as
me.
a kind of a new case. Oh, you are going. So sorry, we have spent. I mean that if it is not mentioned anywhere, it will be very difficult. So if you have already got an employee bond, or a specific clause under the contract saying that this is what we are going to spend on you, and you need to work here till 1 year or 6 months or whatever, and you are breaking that, you will have to pay it as a compensation. So then you can claim that.
But then if I worked for 6 months and my bond says say 1 year, I've already served that 6 months. So your loss could not be the entire amount. So I will dispute that amount that
And
it's
that can be the
so is there
reasonableness on the period of time also. If you look at, you have given a training of 10,000 rupees and you are telling the employee to stay for 5 years, it's not going to work. So reasonableness on the period of the bond, and also the amount of bond.
No, my question is this. When the employee refuses to pay, say that no, I'm not, this is very unreasonable, I don't agree with this, right? This is not reasonable. Whatever you've written is unreasonable. So
Yeah.
obviously it becomes a dispute from there.
Yeah, it
So
will
my
it will become
ability
this.
to cover, ability to recover that money is very limited as the company. So I cannot actually, even if I can prove that I've lost this amount, until
Right.
I can prove that in an arbitration or in a court of law, I don't have an
Correct.
option.
I
So
agree. I agree.
essentially,
But you have other options. If at all that employee has full and final settlement, you can hold it. I mean, it's a again it's a kind of a uh,
arm twisting
arm twisting.
mechanism. Yeah.
So yeah, I mean it is one way you can. Otherwise, you have to go to the court of law. I mean, there is no other way.
Okay. Hmm. I
Okay.
have another question here. So generally, we see a lot of situations. Let's say take it from the employee's perspective as well. We see a lot of situations where there is a 2 year, 3 year bond situation, especially in the IT industry, BPO industry. They have a massive churn where the people are leaving all the time. So they have created these rules that you have to work at least for 2 years, 3 years, and these are all actually not. And they have created various mechanisms to bypass this contractual law. So I mean, really, we are here today. Like the basics, I think everyone knows, but we want to talk a little more details and dig deep into your knowledge and experience on this. That what happens when an employee faces a situation where the employer is insisting that you give me a bank guarantee, or you give me post dated checks, or you submit your mark sheets with me, so that at the time of you leaving I can realize my money, or I'll return it after you are done for 3 years. Or they're asking for, in fact, I heard a very strange case where they asked for a, I am sure some lawyer came up with it. It's they're asking for a, what do you call it, a attorney, power of attorney, right? POA.
Right. Right. Right.
So what do you think of these situations, and how should people deal with this?
No, I think some. If you look at the industry like ITES,
Okay.
okay, and you have people moving 30%, 40% attrition,
Hmm.
and they always come up with this kind of ideas and check with us whether it is legal or not. Mark
Hmm.
sheeting. I mean, so we have given an opinion whether it is. There is no problem in getting the mark sheet and keeping it with you, right?
Hmm.
But once he is out, if he is going to, you're going to keep it for something. I mean, it's not going to work that way.
It is also a criminal offense.
Yeah, it's a criminal offense, and kind of it may not be a criminal offense because if you have a specific document to show that he has submitted along with the documents, then it is with you. But he has all the recourse. I mean, you can go to the court of law and ensure that it is company is releasing it. And these kind of practices are, if you look at any multinational company, I mean, they don't want to get into a practice where employees are getting so the employees are getting really worried about this company.
No,
So
there are good companies, and there are also sweatshops, right? Which are
correct,
essentially
correct, correct.
sweatshops
No,
who
no, I
there
think
are
these
different
are
categories of employers. So and it is a issue, as I
no.
guess
So all
training.
these practices, so
Hmm.
all these practices will prevail till you have, so kind of when. No, I was just thinking in 2009. So
Hmm.
people are not getting jobs, and kind of a situation comes. All these things we will agree and go on. The same time, if you start, in all these industries, what happens is people are, once they are out, they just wanted to go and join some other place. I mean, they don't
Hmm.
have any time to, really, unless and until the issues which you have mentioned, like the mark list is there, and there is a bank guarantee and all, they will have to go and, approach a court of law. But otherwise also payment holding and all those things, I mean, people don't want to wait for all these things, and they will move on to the other company. So normally people don't take it up as an employee issue. You don't
Hmm.
see IT company employees are going to the labor court, and it's exceptions you can see, but it's not a rule. It was not the case with factories earlier. Kind of once you are out of your job, you don't have any job, then you should take it up. So
Hmm.
in that kind of a situation comes in the employment market, people are going to go and question all these things.
Hmm.
So
So,
each one,
but
I mean,
from an employer's perspective, do you think, I mean, these will definitely, at least temporarily reduce churn. So, do you think they should adopt, like, they can adopt this kind of strategies and get away
personally,
with it, get away with it in the long term?
no, personally, I don't agree. if you look at this market, people are doing, so this one way of, discussing on this, right? So if you look at otherwise, people are looking at different options to, curtail,
Attrition
retrenchment,
management policy.
attrition
That's what they call
management
it.
policies. At the
Yeah.
same time, you look at all these companies will talk about all these things. I mean, you come in bicycle, you have this, you have gym. All those things are to reduce attrition and to retain the talent. So
Yes.
same time they will keep their mark sheet. I mean, it is not going to work both ways. I mean, you have only way to make them happy, and that's a long term. It is not going to work. And we have got these kind of questions, and we have not advised in a very positive way. Especially on the mark sheet issues, and bank guarantee. I mean, how will you take bank guarantee from an employee? But it is a small companies. I know some of the companies you have to pay. It is not only bank guarantee. You have to pay this much amount, and then they will take you, and they
And
will
then
use that as a
post-dated
corporate.
checks. Post-dated
No,
checks also quite common.
absolutely, absolutely. I mean, I think these are all not legally right, but I know, so it depends on the employment market. It will all change.
Yeah.
Yeah. So the other point I wanted to so specifically mention on the Standing Orders Act in the context of the your employment contract. So you have to follow all those things, and the Standing Orders Act is to, the objective was to make the conditions of employment precise and definitive. I mean, you know that there is a law here, there, but this is a kind of an employee handbook. It
Okay.
is up. It applies to factories, commercial establishments, and you should have one standing orders and submit it with the authorities and get a kind of approval from them. But this Standing Orders Act is exempted for the, in Karnataka, for example, for IT and ITS uh, companies, and for a long time. Suddenly last year they have taken it out, and now again they've come back with that exemption. So some other states also have exemption, because you don't need to keep your own. You can keep separate employee handbook. You don't need to follow the standing orders and go to the labor authorities and get it endorsed and all. You can have your employee handbook, and if it is within the parameters of all the existing applicable laws, then it is fine. And
I have
mainly,
a question on the modification of the standing orders. How often do a companies actually modify it, or they just accept the the standard which is coming from the statute book?
oh, normally a lot of modification. Especially, so I have to admit that good amount of my clients are all, multinational companies. So what they wanted, for example, IT and ITS is exempted, but when they wanted to, because last year we have filed for at least a lot of companies, we have filed for this standing orders in Karnataka,
Hmm.
and now again they have removed that. But what we have done is, so if they have a international employment handbook, so we will look at, so what is actually getting into, and in line with that, we'll continue retaining that, and whatever changes to be made, we will make that changes. That's the way it is. So modification is there. I mean, you cannot really accept what is there in the act. I mean,
Hmm.
so model standing order, because I mean it is addressing most of the issues of the factory kind of an environment.
Okay. Acha,
Okay.
we can go on for another 10-15 minutes, right?
Yeah.
So we'll wrap up within that. So I wanted to ask a question which I was intending to ask towards the end actually, but I'll
Yeah.
I'll throw it your way right away. So this is
Right.
another very tricky question. Actually, how often do entrepreneurs or businessmen or lawyers face a bribery situation? Where they're dealing with the labor department, and maybe you can explain a little bit on how this labor department, labor inspection system works, and is it a reality that you are facing these kind of corruption issues? Not I'm not saying you are facing, but people are likely to face or not, and how should they approach these things? Because like new age industries, they are very reluctant to get into this kind of things. Also, the lot of people have foreign investments, and it makes their bosses or investors, very liable in the under the laws of their country, which is much stricter than ours. So this is a burning question for a lot of people. In fact, startups are having anti-corruption, anti-bribery due diligences. Now they have to go through this these days. So
Right.
like this is something I would like to hear from you. Yeah.
Yeah. Let me not get into, the reality, and, I don't want to speak in public on that. But I will give you some of the issues we have faced from the, let me start with my practice perspective, right?
Mm-hmm.
We have a specific practice on employment law audit for all the companies. We have done it for British Telecom. We have done it for Qualcomm, IT company from US. But if you look at a medium-sized and small-sized company, I'll tell that I'm going to charge this much amount of money. He will tell, do I need to really bother about it? Because if somebody from the employment department comes, I should spend only this much per month or per year. Why should I bother to spend this much of amount of money on compliances and
Something.
your checklist, and so I can manage. So hope you got what is the
Right.
reality.
Right. Right.
So that's a challenge for my practice, employment law practice itself in terms of compliance. So,
Mm.
but at the same time, if you look at, most of the multinational companies have lot of limitations.
Mm.
They may have different ways to come out of that, but directly, not because of the awareness, and in India as such, you have foreign FCPA is a good example. Foreign
Yeah,
corrupt.
we had the CEO of Walmart being thrown out, right?
Right,
Yeah.
right, right.
Mm.
So if you look at that's a big challenge, and UK law is one step ahead. So
Mm.
they are all not going to do anything. So that is making a little bit of change in the market. To give an example of a Bangalore market, I mean, it is not, people are not going to insist on you, but they do it in a different way and things and all. It is prevalent, but kind of companies are going slightly on a different mode. They cannot do it. And even the Indian companies, for example, FCPA is directly applicable to them. Most of them are, doing work with the US companies, UK companies. Then you have
Yes.
that issue. So I think it is going away in terms of different business reasons, and law from outside also is insisting on. But certain times you get stuck in some place, and then you have to deal with it.
Okay, okay.
Let me
So
let
no,
me
we see a lot of people actually who are asking this question that it's okay, I will spend a little bit more money, will be more careful with compliance, but I don't want to have to deal with this.
No, that's a big challenge on that is the point I was mentioning in the archaic, nature of our employment law.
Hmm.
It's so procedural oriented. You don't know
Mhm.
complete compliance. I'll give you an example. One of the companies is a fully compliant company. I mean, you will not doubt. But
Hmm.
once we have done the compliance, audit,
Hmm.
they didn't know most of the things are required. I mean, if you look at the normal employee, so a employment officer, or the kind of labor department can always come back and tell you that you have not complied this. I mean, you may not imagine that it is just to be complied with.
Hmm. Mhm.
So I think the number of employment statutes applicable, and the number of compliances applicable is very vast. So
Hmm.
100% compliance is a myth in labor law. If you look at it, then you will not be able to do your business.
So basically, we have
So
made a law that that cannot be even complied to.
correct, correct. I mean, it was there. If you look at it, if you are a factory, and you are manufacturing setup, and then that will work. A lot of other things will come in, and it is very difficult. So if an officer want to get you in,
Hmm.
he can bring up with kind of different options. If you look at they will have a printed kind of compliance as violation of compliance. Most of the people would not have done it. So
Hmm.
I think that's a challenge. But reasonable compliance, you will always be able to argue, and everybody, most of the multinational companies want to comply completely.
Hmm.
So how much more time we have? It's
We can go on, like if you like, we'll take some time so that you can wrap up. That's okay. We can
Yeah,
take
yeah.
10 minutes
So 10,
easily.
15 minutes, because
Yes,
the
yes.
other issues also. Just wanted to, how do we deal with, for example, now we see a lot of expatriate employees coming in. So what is
Hmm.
the requirement? I just wanted to, give
Sure.
visa, employment visa has to be there. Then once they come in, there should be a foreigners registration. So that is applicable to any foreigner coming in for more, and they're going to stay for more than 180 days. They have to get a registration within 2 weeks from their arrival in India.
Okay.
There is a foreigners regional registration office in each city. Yeah. And recently, the Provident Fund made compulsory for all the kind of expatriate employees. That's a big challenge. It's a huge salary, 12% of to be contributed to that. And unless and until you have a social security agreement with the countries, we have Belgium, France, Germany, Switzerland, and all. We are aiming at bringing US into it, right? So the advantage is not because expatriate US employees coming here. If we are trying to make them sign the social security agreement, because we have a lot of employees going there, they won't get any social security unless and until they have the green card and all. So this, they so kind of disturb their employees here and try to get a social security. They are not actually bending down. So government is trying to do different things. And let's get into the employee benefits and welfare legislation. Just one is the EPF, that is the Social Security Employee Provident Fund. So 15,000 and above. So that is a recent before election they have made it February 2014. It was 6,500, now 15,000. So most of the white collar employees also will come into it. 12% contribution. Then we have a Payment of Gratuity Act. That 10% or more are working in a company, then you have to have statutory requirement. You can have a policy, or you have a kind of accounting entry for this. Once you complete 5 years of service, you should get a 15 days of for every completed years of service. That's a kind of then you have an Employee State Insurance Act that is also increased to 15,000. And the important fact about ESI is applicable now. Earlier there was a different definition. Any organization which has 10 or more employees, it is applicable. And it is a criminal offense if you don't pay the contribution. That is very important. Exclusive legislation said then you will not, for example, workmen compensation all will not be applicable once you are in ESI. Workmen compensation is one of the earliest one, 1923 one we are continuing. Basically you have a injury and accident and all, you will get compensation. Then there is a labor welfare fund used for the housing, medical care and all for the employees. It's a very small contribution by employer and employee. Then
they're in a very few states, I believe, not in all the states.
Right. Very, very few states. And employee, payment of bonus is one. It is a kind of, depending on your profit and all those, something you have to share. Then so one point is Esop. It's again a retention tool, good retention tool. It's a creating of an ownership culture and all. But the current tax is not really interesting because it will be considered as a perquisite in your salary income and you have to pay tax. Okay. And normally it will be a listed or unlisted company shares you will get. For example, a startup will give their own shares. So that will be beneficial only when you get acquired or there is a merger or something. But in a listed company, I mean, you get the advantage from the day one.
Right.
Most of the multinational subsidiaries and all, they will give their parents shares in India. For example, US company listed shares. And just to run on what are the benefits for women. So one is the maternity benefit. You have 90 days of paid maternity leave, both pre and post delivery or a miscarriage. Then you have an Equal Remuneration Act. You cannot discriminate women on remuneration. And service conditions, that is one act. Then Sexual Harassment of Women in Workplace Prevention, Prohibition and Redressal Act of 2013. I'm sure everybody has heard and read enough of it. Vishaka case, the same line. Internal Compliance Committee is required. And I think that is anyway, it's a new one. The other important thing is women working at night. Right? Night is 8 p.m. to 6 a.m. most of the places. So whether they can work or not, it is not allowed. And only in IT and IT service allowed. So, and you have to provide security. And, so one of the, HP company had a big problem when, security was not given. And, even the MD will be held liable. The last part is on the termination. So I have already mentioned on that there is no hire and fire policy. You can go on hiring, but when you are firing, you have to be careful. Some of the things we have already discussed during your questions and answers. Termination, normally it will be a termination with cause or a without cause. Fault-based termination or a no fault-based termination. With the cause, it is called dismissal or discharge from service. There should be a misconduct or there should be some reason, and that reason has to be inquired. You cannot say that an employer, you have done mistake unless and until it's a grave misconduct, right? So then that has to be proved. And if
what about non-performance? If an employee is constantly non-performing, can I
non-performance is a cause, and that cause has to be independently looked at. Unless and until you have a clear data, and that is well accepted data, and kind of prove that there is a non-performance. Otherwise, I don't suggest that non-performance is an easy way to get out. You have to do an inquiry. I mean that non-performance has to be, because two parties are involved. One party cannot take a call.
But
and employees can always seek redressal.
Hold on, I'll just stop you there, because this is a very important thing. Because most of the companies have to fire is not because of any other reason, but because of non-performance. Someone is not performing well. This is the most common reason why someone has to be fired. So what, are you saying that we cannot do that at all, or?
No, I'm not saying that you cannot do that. If you are telling that the reason for firing is non-performance, you have to prove it. You have to conduct an inquiry and see whether it is non-performance is actually happened. Otherwise, you are taking a call, right? And second thing is, you look at all those firing, the documentation of that firing.
Okay.
There may not be a reason shown as non-performance. There will be some other reason. So I think that's the way it is handled. Employees can always go to a court of law and ask for the redressal. It can be a reinstatement or a compensation. I mean, these are two options he has. Court can look at it. Then if it is a without cause, resignation, retrenchment, retirement, or an expiry of an employment contract, these are the reason for the no cause. And again, you have a contractual and statutory requirement for termination. Contractual, if it is, you cannot have a contractual termination clause which is below the requirement of the statute. So if it is, for example, 1 month notice is a requirement, so you give 3 months notice in your contract, you should follow what is in your contract. But if you give a 15 days notice in your contract, you should follow 1 month, because that is the statutory minimum.
Okay.
So I think, one is the Industrial Disputes Act. For workmen, not managerial level employees are covered, supervisory capacity not covered. Retrenchment provisions are mainly on the number of employees in the establishment. If it is less than 100 workmen, 1 month notice you have to give, indicating the reason for the termination, retrenchment. And you have to pay payment of retrenchment compensation, 15 days salary for every completed year of service, and notice to the appropriate government. These are the following. Then, but if it is 100 or more, then you have a onerous provision for that kind of companies. Okay. You have to give 3 months notice, prior permission from state government for retrenchment. So then standing orders and Shops Act has a provision for 1 month notice minimum you have to give. And again, we will come back to the industry practice, how employers are managing this. If you look at most of the industries, especially the new industries, somebody is getting fired. I mean, so A company is firing B. B doesn't want to get fired, so that's a conflict. If you deal with US companies and all, they always tell that you terminate. What is the big deal? They have a hire and fire policy, and they don't really consider.
But find another job. That is the idea, right?
Absolutely. So yeah. No, here also you can find another job. But if you look at, somebody has a track record of a termination, companies will look at, so he got terminated, something wrong, right? So there is a taboo there. So normally, so one example I'll give you. We have advised a company to some 40, 50 employees across country, and so we specifically told them that it has to be structured in a different way. They said termination. We have done all termination. In the end of the termination documentation, employees came back and said, it's all fine, we have signed. Can we get a resignation acceptance letter? Because that is the mode. You got my point.
Yes,
So
yes.
basically what happens is these kind of situations, most of the times, the employer will talk to the employee, tell that, your performance, that, this, so it is better you resign. So normally he will resign and go. And he
Right.
will get all the for example, he doesn't need to, if he is resigning, who has to, he doesn't need to pay any if I'm resigning, I should pay compensation to the company, but normally company will pay compensation because it's a compelled resignation. So that is the mode accepted and
Right.
moved on by all the companies. And so you have to have if it is a senior employee, you should get a indemnity from him, and there should be a release agreement, and or something, full and final settlement, so then they'll not come back again. I think these are the things which I covered. And
Okay.
basically, to conclude, I would say that most of the laws, so we interpret and get it in a kind of a uh, available position, but most of the laws are not addressing lot of new industry issues. So
Yes, yes, yes.
we will see that in the coming years to make changes. I'm not talking about the high end kind of discussions. I know that labor reforms and all those things. I'm telling that to address the regular issues.
Yes, yes, yes.
I'm not talking about, so, and I also see a huge problem in there. We change all the laws and, you have a problem. So employees
So,
have to be protected in any environment, but it should also allow the business to go on in a smooth manner. That's the kind of changes we require.
correct.
So
Otherwise, there will be no employees.
absolutely, absolutely, no employees and no employers also.
No employers
So
also, right?
they are interdependent.
Yes, yes.
I think this is the end of it, and thank you for all.
Okay. Thank you very much. We haven't gotten any questions yet. I believe the questions are accumulating somewhere in my email, maybe. Will you give me a second to just check
Yeah,
if there are a few questions? We'll address them
we
quickly.
will address now, or
Yes, we'll address now. So we have one question. You would have gotten some questions even over Twitter, so you can reply to them over Twitter as well. Some of the
I'm not in Twitter.
you are not on Twitter, okay? But you can on
we
this
were, we were
occasion,
we were
you on
just
this.
we were just discussing about the Facebook in
Uh-huh.
Bangalore. We have about 4.5 million
Facebook users.
accounts, Facebook
Oh,
accounts. We have
oh,
only 9 million. Yeah, I think 9 million, right? 9 million people here. Almost half of the people have a Facebook account, but
yes.
I am in that other half. Yeah,
No, no, no. Maybe this could be a good occasion for you to, interact, and this will
right,
definitely give you some followers to
right.
start with
Yeah,
on Twitter.
sure.
So, one question from Aditya Bikram Dubey from Kolkata.
Right.
He's asking, what are the labor laws applicable to lawyers working as a retainers in law firms? Is it only contractually driven? Yeah. So
Okay.
this, I think, is a question
Uh,
close to their heart.
yeah, yeah. Being a partner, uh, I should be able to address that. So one is that mainly, when you are a retainer, you are not an employee, right? So that's the way it is structured for different reasons, maybe tax reasons or. So then it is not directly, very few laws are applicable. And
Mhm.
even if you are an employee, uh, let me give you because I don't want to give a blanket kind of an opinion on this,
Mhm.
because let me take example of a shops and establishment in Bangalore, Mumbai.
Right?
Even if you're an employee, there is a specific exemption. You're not coming under this
Okay.
shops and establishment. You don't need to comply. You don't need to register.
Hmm.
That's an advantage. Same time, the other, compliances like professions tax. That's a requirement for that. Also, you have limitations, right? You should, for example, these are all I'm getting into my, on state. Um, One is that on the professions tax, you should have at least a standing of 10 years. Then you should look at, I mean, it's a personal, professional issue because you're a consultant. You go and register.
Mhm.
So these are the, some of the issues. And obviously, the female, so women related laws are applicable. So
Mhm.
that will be applicable even for not only law firms, even
Everyone.
at home, you have to be looking at that laws.
Mhm.
And yeah, few other laws which are really applicable to unauthorized sectors will be applicable to us.
I think another question we have received on the similar lines is that about have some lawyers, some law firms are employing lawyers as an employee, and
Right.
others are hiring them on a consultant basis. So is there what is the legal position on this?
No,
Can
this is
full time people be hired as consultants?
yeah. No, so I'll tell you, so sometimes it is both ways people are looking at, and so one big reason is that lawyers want to be independent professionals, right? So
Yes,
that is one way of looking at it.
they also save tax that way.
It's a taxes. The tax is a
Yeah.
driving factor. Let
Factor.
me
Yeah.
admit that,
Mhm.
because to give an example, we had a lot of service tax issues, and kind of we wanted to get all the people to be
On
employees.
employees. Okay.
So no lawyers wanted to be employees.
Right.
I'll give it. I
Right.
think
Right.
Gaurav has been asking something on
Yeah. So Gaurav is sending
migrant.
across some questions.
Yeah.
Okay. This is on migrant workmen. Okay. Interstate Migrant Workmen Act. Okay, Gaurav, will you please also tell us who asked the question? Maybe Raja, you can start addressing it. What is the Interstate Migrant Workmen Act 1979? So, are we still following this law? Is it affecting the industries in some way?
Not really. I mean, so let me. I know that there is a this kind of
I
law is
believe
there.
the threshold is very very low for
Yeah,
this.
I mean, it is mainly uh, not really in this new industry kind of a situation. So construction workers and all those things.
Mm.
Uh, yeah, I mean, I have not personally dealt practically. I know what is this law is, but it doesn't really affect when we deal with this. With the
Correct, but we have heard of this law very recently in the media a lot because of Mr. Raj Thackeray, who raised this
correct,
issue
correct.
that workers are not registering themselves in or companies are not registering them in Bombay. So, do you think this is a there is a real obligation on companies to register migrant workmen who are earning above, let's say, 10,000 rupees in a month?
Uh, Let me admit that I'm not technically I don't know what is the kind of a
Okay.
migrant employee definition.
No, but
But
what is your
I have
experience
not
of?
I have not seen till now. Here anyway we are uh, not following this. We are not filing anything under Workmen Act.
Hmm.
Yeah. So unless and until it's a kind of real estate construction workers are coming in
Right.
and all, they are looking at it.
Hmm.
So you have
Okay.
lot of workers coming for carpenters and other workers coming in. They are registering under this. I've not seen any IT companies or so new companies are
Hmm.
registering under this. I mean, it is maybe
Okay.
a definition will exempt.
Okay.
Let me admit that I don't have that complete details.
Okay, so we have heard that some of the state governments are trying to going towards one window registration, right? Single window registration for these
Huh, huh.
various laws. So do we actually have these laws anywhere in India yet? And which state would you say is the most convenient to start a new industry right now in terms of labor law and how onerous the labor law is? Is it what according to your experience is the difficult states and which are the easier ones? More friendly towards business.
No, it is. If you look at the legal framework as such, is somewhat similar, right?
Similar. Okay. Hmm.
Somewhat similar. I mean, it will be a little bit different here
No,
and
I'm
there.
sure you often get questions from your outsourcing clients, that where should I
No.
set up
That
my,
is there. That is there from the.
yeah.
But basically, they will not really ask from the employee law perspective. They'll ask from the tax perspective.
Okay.
Most of the clients.
Hmm.
And employee friendly is one thing, is that, so how, to give you an example, in Karnataka,
Hmm.
when Krishna was the chief minister, there was an clear indication. It is not really law as such. Clear indication that no labor officer should go and visit any IT companies.
Okay. Hmm.
So, and most of the people, I had discussion with a lot of CEOs and all, so uh, they said, I mean, labor laws are not applicable to us. Kind of, so it is the practice has become like that, and people thought it is not. When then people change, then kind of then made. So you have to really look at what government is there, how the bureaucrats are reacting to issues. It is not the law really make lot of
Right.
difference.
So I
So some of
believe
the
as
states
a
like, yeah, some of the states like Karnataka, Bombay, and Jharkhand, and all, as for example allowing women to work and these kind of things. Then you don't need to follow standing orders for some industries. Otherwise, more or less same. But how the bureaucracy and the government reacting to the industry requirement, that's the main
that
kind
is
of factor.
the factor. Okay. All right. So another question that I had about this is that where do you see that the do you see a lot of changes in the government policy towards labor law happening over the next few years? And this is one question, and the other question that I'll end with that we have got from another student, Sahana Sahana. So she's asking this question that to what extent do you believe that a lawyer who's not actually practicing in the labor law specifically should enhance their knowledge about this, and similarly about HR professionals who are HR professionals, to what extent do you think it will help them to know some of these labor law and employment law concepts?
Okay, let
There are
me
two questions. Huh.
take her question first, and so I would suggest that you need to have basic knowledge. I mean, most of the employees, forget about lawyers. I'm telling, at least most of the employees should have basic knowledge. Otherwise, how are they going to address these issues?
Okay.
And I do work in all this employment law work. I do work with HR professionals.
Hmm.
They really need to know about what is the current employment law. And some of the practices are not in line with what is the requirement under the law.
Hmm.
That is one thing. And I strongly recommend HR professionals to have basic knowledge, at least attend and kind of have so we some of the seminars like this, and kind of maybe industry specific issues I have done for some of my clients. For example, some of the US clients, their HR head, a legal head and all, will come here, and we all together do a kind of program for a day. This is
Hmm.
required. I mean, if you look at, so I'm not making it generic. If you look at on the the new act on the um, sexual
Sexual
harassment,
harassment. Hmm.
you need to educate people. How do you know that it is a? I mean, if you look at the definition and all, you will never be imagining that it is a harassment. People
No,
go
it is
on.
also a requirement under the law that you have to sensitize the
Yeah,
employees
yeah. That
periodically.
specific law. That specific law. And if you look at all the all other laws also, like most of the statutes have a specific provision that you should have an abstract version of the act, kept it in a conspicuous part of your office,
Yes,
in,
yes.
in any factory. So I always used to kind of joke about that. If you are really following that law, all these nice offices, kind of reception will have only acts. You don't need any paintings and all. You will have abstract acts hanging around. So I think that is practically not possible. What we tell them is that, even now I'm telling some of these IT companies, I'm telling that you get all the abstract. I'm sure they'll come. Somewhere you hang or somewhere you keep it.
Uh-huh.
So I think that means what I'm trying to tell is there is an awareness required. That's why they have said, for example, in the factory and all, they should have an abstract in English, if it is in English, and the local language you should give it. So
Yes.
employees should be aware, and HR professionals should be aware. I think it is a continuing program should be there from the uh, employment lawyers, or kind of. And the other question she asked is, I'm sure she will not be going to practice as an uh, employment lawyer, but so if you are a corporate lawyer, you need to do a due diligence. Don't you want to get into the employment law issues? So I agree, if you are in a kind of a bigger setup, you don't, you have employment law people will come in and check, but it will be all interconnected, right? So I think that basic knowledge, I'm not saying that you need to go into really in depth, but there should be a knowledge, and you should update on the employment law, even if you are a corporate lawyer.
Okay. So we have some other questions on deputation and stuff, but I think we are going to skip those questions for today.
Right,
Maybe we will do another session with you sometime if you can find time for us,
right,
and
right. No problem.
we'll discuss these
Yeah, so
more of these issues.
if you can, yeah. So the some of the questions, I mean, yeah, I think we can end here. And the last question you asked, you were referring one question, right? What was that?
Yeah, yeah. So the question was about the policies. How do you see the
Yeah,
policies
yeah.
of in
No,
India
I
headed?
think we can end with that answer, because I have also worked with some of the, kind of, if you look at most of the big companies, uh, will have someone in HR working on the policies itself. I mean, to how to change and how to make it, So basically, there are a lot of work going around on that. For example, each sectors also looking at different changes. For example, IT companies, NASCOM, and all those people are all working to make considerable changes to ensure that business is smoothly run. So I think that is, so if you look at every time all these industry bodies and the kind of uh, big companies representatives go and represent to the government ministries, also to the employment, and all these industry bodies will have, we have Bangalore Chamber of Industry and Commerce. We used to have interaction with all the labor officers at that level, and to discuss on what are the issues actually. I think there is a kind of dialogue between the government and the industry, and it is changing. You can see that. As I mentioned in the conclusion, that I mean we need to see some of the changes. We don't need to see a kind of revolution in the employment law, at least to ensure that even the new industries will be able to smoothly run their business.
Okay. All right. This is very good. Thank you very much
Thank you.
for coming to this webinar and sharing your very valuable
Sure.
insights and your answers, like answering so many questions. We have
Thank you.
definitely overshot the time by like a margin. And
Yeah,
thank
thank you.
you for
Thank
being
you.
patient and answering all questions.
No.
Some of the students have said that in case they want to connect with you in the future, given that you said that you don't have Facebook or Twitter, you are not available on social media, how can they ask you questions or seek your guidance and mentorship?
I'm on LinkedIn.
You're on LinkedIn,
That
okay.
is that LinkedIn.
Okay, so yeah, so you can actually your maybe you can share your email ID or something that they
That
can.
is also fine. Please.
Okay, so whatever it's up to you. Like whatever you're
No,
comfortable,
so
you can share.
I can share my email ID, no problem. So I will. You have already got my email ID. You
I
can
have,
share
I
with
have.
people. Yeah, no problem.
Okay, so if
And
anyone,
I'm
if any of
also in LinkedIn.
LinkedIn, yeah,
Yeah,
LinkedIn. So
yeah.
definitely we'll do something. We'll share your LinkedIn ID along
Right.
with the video when we finally
Sure.
post it.
Sure. Right.
And anyone, if you have, like you have written, if you have any specific questions to ask, you can say it across to us and we'll forward it to Mr.
Absolutely.
Raju.
Absolutely. Yeah.
Okay. Thank you very much, sir. It was a pleasure talking to you and discussing these labor and employment issues.
Thank. Thank you. You made it very live. Thank you.
Thank you
You
very much.
made my job easy.
And no, it was definitely very interesting and a learning experience for myself as well.
Thank you. Thank you. Thank you all for
Thank
participating.
you, everyone. Bye. Thank you.
So, bye.